Hi beautiful people, welcome back. Hope everybody is doing fantastic wherever you are in this world. I hope everybody has made it home safe from work, having a wonderful evening, had a good dinner. Yes, you guys, this is my second upload for the day. I'm very proud of myself. And I just found out as I finished upload my video and I was checking Twitter and I see Al Rubin actually posted a new filing from 7M, which is plaintiff's response to defendant's motion to compel. Before I get into this, my usual disclaimer. Please do not take what I say as fact. Feel free to do your own research and come to your own conclusion. So let's just back up a little bit, because last week, was it last week? Yes, it was last week or the week before. You see, you guys, these days are going by so quick I can't even keep track of time. But let me put it this way. Katie Joy's recent filings, which were defendant's memorandum of law opposing an amended scheduling order, memorandum of law opposing plaintiff's motion for a temporary injunction, defendant's memorandum of law opposing default judgment, and declaration of Graham M. Martin. I did not give my feedback on this because everybody else gave feedback on it, and I thought, so much else is going on, I'll let it go. But something that blew my mind and still blows my mind was from something Graham M. Martin actually stated at the end of his declaration. But we'll get into that. But first, let's go back a little bit, okay? In April, when 7M actually served Katie Joy with their complaint and amended summons, she did not respond to their complaint. Instead, Katie Joy filed a motion to dismiss. Then on August 24th, her motion to dismiss was denied. And under Minnesota rules, which I remember this because Nate the lawyer actually spoke about this, it says that she has 14 days to serve an answer since her motion to dismiss was denied, which she did not do. When Katie Joy, an attorney, found out about the default judgment, the scrambling started. She posted the screenshot because, Katie Joy feels courts of public opinion matters every which way. And then she made this post which says, when the judge denied our motion to dismiss, the judge did not set a date due for the answer to the complaint. We had already responded to the lawsuit and were never non-respondent. The answer is now filed in court. She just, in my opinion, contradicted herself right there. To which she then posts on Twitter, please find, filed, and served alongside this letter a copy of the answer that we drafted and that I thought had been sent last month. Given our typical manner of corresponding without delay, if you had wanted an answer and had not received it, I would have thought a simple email request would be sufficient. In what world, boo-boo? This is such an important court case. Do you think that 7M's lawyer is going to keep running after y'all? When if y'all don't respond, it benefits them? It's like, come on, you're much more smarter than that, in my opinion. This screenshot is part of a letter that he sent to 7M's attorney, and it all fits in with the answer he gave in the latest motion, which I'm going to get to. Now, this what had my mind blown, because at the end of Graham Martin's declaration, this is what he says. The defendants have been diligent in their responses to the plaintiff's request, have met their obligations throughout this proceeding, and corrected the mistake regarding the answer as soon as we were made aware of it. Corrected the mistake? It was a mistake that you forgot. It was a mistake that you didn't make sure that the answer was sent. It was a mistake that you didn't 100% check that it was received, sent through, gone, they received it. Gotcha. If a death in the family is not good cause for missing filing the answer, I don't know what is. What the fuck? I am a nobody. I am no lawyer. But how fucking sarcastic and arrogant is that? After listening to Uncivil, He said the best excuse you can have for missing that deadline, probably if you were in a hurricane. He states and he says, if a death in the family is not good cause for missing filing the answer, I don't know what is. But you know what I think? Being an attorney, such an important job. Don't you have backup? You clearly have a paralegal. You clearly work in a law firm where you're surrounded by other attorneys. So when you go on vacation, Graham, who takes care of your cases? Who makes sure that if the court files anything, it's going to be brought to your attention? If you need to do anything for the court, it's going to be sent to the... If anything happens in your absence, so nothing gets done, basically, that blew my mind away. Let me know what you guys think about that. It is like, wow. And in my opinion, he's disrespecting and insulting the judge's intelligence. That's just what I think. Now, before we get into the 7M filing, first of all, my deepest condolences go out to the Martin family for the loss of whichever parent they lost. And I mean no shade by saying that, because it's very confusing in the filings. Secondly, all credit goes to Al Rubin. I will list their Twitter down in the description box so you can go and follow them. As I say, and I'm going to stipulate once again, I am not a lawyer. I don't know jack shit. All I'm doing is reading these court documents. You can think and come to your own conclusion, but all I'm saying is I do not know anything about the legal system. But let's read this. So this is 7M Films Inc., Robert Shin, Miranda Derrick, James Derrick, the plaintiffs, Catherine Mansky-Paulson, and Without a Crystal Ball as the defendants. Plaintiffs' response to defendants' motion to compel. Defendants have prematurely brought forth the motion to compel as the court has not yet adjudicated plaintiffs' motion for protective order regarding discovery. Plaintiffs have properly complied with its discovery requirements at this point, and defendants' motion to compel should be denied. Argument. Defendants have not shown cause for their motion to compel. Defendants' own motion include facts to support its motion to compel, which are not true. Defendants' motion to compel states discovery was served upon plaintiffs on August 26, 2022. Plaintiffs were served with discovery on August 5th, 2022. Regardless, on August 26, 2022, plaintiffs filed a motion for a protective discovery order limiting what sensitive information sought after in defendants' discovery could be viewed by defendants and limiting the ability to share that information with third parties. After attempting to answer discovery without cooperation of defendants' attorneys to stipulate to a protective order and prior to the court's order regarding plaintiffs' motion for protective order, plaintiffs realized that they would be unable to answer the discovery sent by the defendants as written without disclosing sensitive information. Following this, on September 1st, 2022, prior to discovery due date, plaintiffs sent correspondence to defendants stating, on August 26, 2022, we filed a motion for protective discovery order. In this case, the motion was filed due to the sensitive nature of the documents being requested by defendant. We will not be responding to any discovery request until an order has been issued on the aforementioned motion. Plaintiffs have sent numerous emails to defendants informing them that if they stipulated to a protective order, plaintiffs would send responses to discovery that date. Defendants refused to stipulate to a protective discovery order, asking for the court's order on plaintiffs' motion for protective discovery order, have further added time and expense by setting forth this motion to compel. And everybody that actually read Katie Joy's filing said it's a fucking waste of time. They didn't say fucking, I'm just adding that. As plaintiffs made a timely motion for protective discovery order and informed the defendants that they would respond to discovery as soon as the court issues an order on that motion. Plaintiffs have not failed to respond to discovery and defendants' motions to compel as not supported by Minnesota law. Dated November 8th, 2022. First of all, if this judge does not get pissed, whoever they are, definitely deserves an award for patience, because this 7M lawyer makes it clear once again that they have no problem giving the discovery until the judge has ruled on the motion for protective discovery order, because that information that Katie Joy is asking for is very sensitive information. And as they now know the reputation of Katie Joy, that she divulges personal information, private information, sensitive information with no regrets and no thought behind the kind of information that she's actually putting out there. As long as it gets her the clicks and the views and the recognition, she doesn't give a damn. But you know what the sad thing is that people know you, and I'm talking about without a crystal ball, to just have no regard to what may hurt people, the sensitivity, the nature of the information that she puts out. And also, this attorney makes it quite clear Katie Joy's attorney is prematurely bringing forth this motion. And I truly do take my hat off to this attorney, because clearly she's looking out for her client's best interest, making it known that this is a waste of time. Whatever she's filing is a total waste of time, and they have to respond, which means her client, 7M's attorney, needs to be paid for every single motion that she's filing, which she feels is unnecessary, because all you need, Katie Joy, is a little bit of patience. But no, not Katie Joy. Katie Joy knows it all. Katie Joy, at this point, I think Katie Joy, the way she feels she knows everything, she can be one of the Supreme Court justices. That's what I'm just saying. Because this is ridiculous. It's like you're throwing everything at the wall, expecting something to stick. But that's what you're paying your attorneys for, Katie Joy. Maybe you should just hire the right attorneys, But I don't know, you guys. What goes through? I know we all don't think alike, and I don't know. It's just all left to be seen. But that's it for today. Hope this does not end up long. And thank you so much, you guys, for joining me. I truly appreciate you. Have a wonderful evening. Please be safe out there. Be kind to one another. And don't forget, make good memories. Bye, guys.